એમાં તમે આરોપી નથી, એમાં તમે આરોપી નથી. યસ, નેક્સ્ટ.
એક આમાં તો હકીકત એવી છે સિવિલ ઓફેન્સની અને હાલના મુદ્દાની કે બીટ કનેક્ટ કંપનીના નામે એક કંપની શરૂ કરવામાં આવી. બીટ કનેક્ટ પોઈન્ટ બહાર પાડવામાં આવ્યા. એ નામે રોકાણ મેળવવામાં આવ્યું અને ઓલ ઓવર સડન એ કંપની બંધ થઈ ગઈ અને એમાં રોકાણ કરનારના ઉઠાપત કરવામાં આવ્યા. એ રીતની સાહેબ ફરિયાદ છે. બીજી ફરિયાદમાં ફર્સ્ટ એન્ડ ફોરમોસ્ટ સબમિશન કે એમાં અમે સાહેબ શેડ્યુલ ઓફેન્સમાં અમે આરોપી નથી. સાહેબ અમારા ઉપર આક્ષેપ એવો છે કે આરોપી નંબર 4 ના પુત્ર અને 5 ના ભાઈ સુરેશ ગોરસિયા, જે હાલના કામે બી સાહેબ આરોપી છે, એ સાહેબ શેડ્યુલ ઓફેન્સમાં આરોપી છે. એના ઉપર આક્ષેપ સાહેબ એ રીતેનો છે કે આ કામના મુખ્ય આરોપી સતીશ કુંભાણી, કે જેણે આખો પ્રોગ્રામ ડ્રાફ્ટ કર્યો અને પૈસા એકઠા કર્યા, જેના ખાતામાં પૈસા આવ્યા એવું કહેવાય છે, એને જે રોકડા નાણાં આવતા હતા એ રોકડા નાણાંનો વહીવટ સુરેશ ગોરસિયા પાસે કરાવવામાં આવતો હતો. અને આ સુરેશ ગોરસિયાએ સતીશના કહેવાથી સતીશ માટે એના પિતા અને એના ભાઈના નામે મિલકત ખરીદ કરી, ને એ મિલકત ખરીદ કરી એમના નામે, એના માટે આ બંને જણાને આરોપી બનાવવામાં હાલના કામમાં આવ્યા છે. સર હાલના કામે અમારા ઉપર જે આક્ષેપિત મિલકત છે તે ફરિયાદના પેરા નંબર 11માં ટેબલ નંબર 3 અને 4 એમાં સાહેબ કરજણની સાયણ વિસ્તારમાં આવેલ 2 જમીનો છે, જેમાં એક પિતાના નામે છે ને એક પુત્રના નામે છે. એક આરોપી નંબર 4 અને એક આરોપી નંબર 5. સાહેબ ઈડી દ્વારા આમાં ઇન્વેસ્ટિગેશન કરવામાં આવ્યું છે, જેમાં અમે કોઓપરેટ કર્યું છે. એમાં ક્યાંય પણ
તમને અરેસ્ટ નથી કર્યા?
અમે અરેસ્ટ નથી કર્યા, દેટ ઇઝ ઓકે સર, બટ નાઉ આઈ એમ કમિંગ ટુ ધ સાહેબ ઈડી માટે મહત્વનો ઓફેન્સ અમારી સામે પ્રસ્થાપિત કરવા માટે સાહેબ નોલેજ હોવું અમને ખૂબ જરૂરી છે. સાહેબ થ્રુ આઉટ ધી ઇન્વેસ્ટિગેશન એન્ડ ધ ચાર્જશીટ અમને એ નોલેજ હોય કે આ પૈસા બીટ કનેક્ટ કંપનીની સ્કેમના નાણાં છે, એ બાબતનું લેશ માત્ર પુરાવો સાહેબ નામદાર કોર્ટમાં રજૂ નથી. સાહેબ અમારા પણ સ્ટેટમેન્ટ થયા છે. અમારા સ્ટેટમેન્ટમાં પણ એવું જ પ્રસ્થાપિત થાય છે કે આ મિલકત સુરેશે લીધેલી અને સુરેશ જાણે છે આ વિશે. આ પૈસા ક્યાંથી આવ્યા એ અમે જાણતા નથી. સાહેબ આ અમારા કબજા ભોગવટામાં હોય ફિઝિકલ, એવું પણ સાહેબ પ્રાઇમા ફેસી પ્રસ્થાપિત થતું નથી.
Yes.
સર ફરિયાદ ફાઇલ કરવામાં આવી એમાં સાહેબ પેજ નંબર 38 એમાં અમારો સાહેબ રોલ લખવામાં આવેલો છે, જેમાં સૌ પ્રથમ સાહેબ આરોપી નંબર 4. એ સાહેબ મેં જે કહ્યું કે અમે અમારા નામે મિલકત ખરીદ કરવામાં આવી એ બાબતે છે સાહેબ, એ રોલમાં દરેક જગ્યાએ નોવિંગલી અમે કરેલું હોય એ બાબતે ઉલ્લેખ કરવામાં આવેલો છે. સર અમારા નોલેજ બાબતનો લેશ માત્ર પુરાવો હાલના કામે ચાર્જશીટમાં રજૂ કરવામાં આવેલ નથી. અને સાહેબ હાલના જે આરોપી છે આરોપી નંબર 4 એનું સાહેબ સ્ટેટમેન્ટ આ કામે રજૂ છે. પેજ નંબર 804 એનેક્સર ટી ઉપર સર. રિલેવન્ટ પોર્શન છે પેજ નંબર 808. सर एमा प्रश्न नंबर 8 છે शायर में आपके नाम से खरीदी गई जमीन के वास्तविक मालिक कौन है? असली मालिक का मुझे नहीं पता, इस बारे में अधिक जानकारी मेरा बेटा सुरेश ही दे सकता है। क्या यह नेक्स्ट क्वेश्चन से, क्या यह जमीन सूरत पुलिस ने जब्त कर रखी है? यदि हाँ तो क्यों? यह जमीन सूरत पुलिस ने जब्त कर रखी है, इस बारे में ज्यादा जानकारी मेरा बेटा सुरेश ही दे सकता है। तब एमने ईडी द्वारा एमनो नॉलेज बाबते विशेष कोई पूछवामां નથી આવ્યું કે આ તમારા છોકરા પૈસા ક્યાંથી લાવ્યા, તમે પૈસા આપ્યા કે નહીં? સાહેબ નેક્સ્ટ, क्या જે ટ્રાન્ઝેક્શન છે સતીશ ના ઉઘરાવેલા પૈસા પિયુષ સાવલિયા ઉઘરાવે છે, પિયુષ સાવલિયા પાસેથી સુરેશ લાવે છે, ને સુરેશે ક્યારેય પણ એના
ભેગા હતા એવું કંઈક તમે રજૂ કરવાના હતા, બંને ભેગા હતા. પણ ભેગા હતા એવું કેના આધારે કહો છો? બંને પેલા ભેગા ચાલતા હતા એવું કંઈક તો આપો. એક જ કોર્ટમાં તો એવું કહો છો ને તમે. પણ એના માટે તો મુદત આપી હતી તમને. એવું ક્યાં? સાદી કોપી નથી. ઓનલાઈન ઓર્ડર આઠ ઓર્ડર થઈ ગયો છે. બે માંથી એક કેમ નથી બતાવતા? તમારું પેલું કે બંને એક જ કોર્ટમાં ચાલતા હતા અગાઉ, તો એના માટે કંઈક તો બતાવી શકશો ને કે આ એક જ કોર્ટમાં ચાલતા હતા.
She has been made an accused in this PML case. So far, accused number 2, son of the applicant is concerned, he is facing the main case that is under GTIG Act. As per the case of the authority, it is alleged that the proceeds of crime which has been taken by the original accused of the GTIG Act or GTIG offense, where the accused number 2 is also an accused, that money used to purchase the property in the name of the present applicant, therefore She is made an accused in this PMLA case also, as accused number 6. The exact allegation, if your honor kindly see, page 29 of the complaint. Page 20. In the original.
Yes, yes, what is it?
So Varsabin Mawani had shown, am I?
Yes, 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 yes.
So Varsabin Mawani had shown to have purchased the attached immovable properties by taking loan. Satish Kumbhani discloses in his statement dated 15/2/2021 under section 50 of the PMLA that he had purchased the agricultural land to Dhaval Mawani in the name of Dhaval Mawani's mother Varsabin Mawani at village Vihan, Taluka Ahmed, district Surat, for which he had given cash of rupees 15 crore to Dhaval Mawani. This fact is further corroborated from the statement of Suresh Gorakhia, close associate of Satish Kumbhani, dated so and so under section 50 of the, wherein he discloses that Dhaval Mawani had purchased land at the village Vihan in the name of Dhaval Mawani's mother. Further, on being asked about the properties held by him and his family members, Dhaval Mawani in his statement dated 12/2/2021 disclosed the details of the properties owned by him, his father, but did not disclose the properties purchased by his mother Varsabin Mawani. Further, the modus operandi adopted by Satish Kumbhani in concealing the proceeds of crime is that the purchased property in the name of various persons, including Varsabin Mawani, by paying the proceeds of crime in the case to Dhaval Mawani and Suresh Gorakhia and arranging loan from the various persons for such purchase of immovable property. As such, the person in whose name the properties were purchased used the proceeds of crime to purchase the said property, but arranged the funds through the banking channel by showing to have taken loan from the other person. From the above, it is evident that the properties purchased in the name of Varsabin Mawani are purchased from the proceeds of crime, which were given by Satish Kumbhani to his son Dhaval Mawani. In this light, discussion made here. So this is the base how the present the accused number 6 has been involved in this case. But if you want to kindly see the page 41. There is a table of the property which is alleged to have been purchased.
Yes,
That is the item 6, Varsabin Mawani. That the accused purchased the immovable properties in her name by using the proceeds of crime, whereby the accused acquired in proceeds of purchased the proceeds of crime. Now, Your Honor may kindly see page 18, 1 page. Our statements have been recorded. In our statement, we have explained everything. How it is there say that the accused of the GPID case have used this money to purchase this property. But so far, when the investigation was started, our statements have been recorded. We have explained that how the funds has been arranged. At no point of time, the authority is alleging that we had knowledge, or we had any mens rea to commit this offence. the element of mens rea is very essential in the criminal offences. Your Honor, may kindly see. Had it been the case, if even if it is believed for the sake of argument that the so-called proceeds of crime have been used by accused number to purchase the property in the name of mother. Your Lordship may, Your Honor may kindly see that is there any mens rea on the part of the lady accused who is happens to be mother of accused number 2 that to commit an offence under the PMLA? Is there any knowledge that this is the proceeds of crime and the son is being using the name of the mother and mother was knowing and mother had supported the son to conceal the amount or to conceal the proceeds of crime? From the entire complaint, the prosecution is absolutely silent about these two important aspects, about the knowledge and about the mens rea of the present activity. So in my respectful submission, the present applicant accused number 6 is being dragged into this PMLA case only because in her name, some property is purchased, wherein there is a absolutely explanation has been given by the applicant about the fund. However, only because she is mother of accused number 1, accused number 2. And accused number 1 is something alleging against accused number 2. As I have read over, that is the crucial part. Accused number 1, Satish, is alleging that he had given the fund to Dhawan. And then the authority is alleging that Dhawan has used this fund to purchase the property in the name of the mother. That is all. Therefore, in my respectful submission, the applicant accused number 6 is being dragged into this offence only because she happens to be mother of the accused number 2. There is no evidence to frame the charge against the present applicant accused number 6. Further name to even frame the charges under the PML for the offences either under section 3 or section 4, 5 or PML. Two things are required to be established even from the prima facie from this impugn complaint. It's a private complaint. In this complaint, two things are required to be established by the prosecution or more. One is about the knowledge of the offence, not knowledge about that what his son is doing, how he is earning the money, from where he is earning the money. About the offence, that is one. Secondly, the element of mens rea. There has to be mens rea of the accused person from the complaint itself that because of this he has committed this crime. How the offence is committed, where the offence is committed, who committed the offence. There has to be prima facie material before the trial, before the honorable court to even frame the charge. In my respectful submission, there is. So these two important things are not being satisfied from the prima facie reading of this complaint. Right. So in this background of it, I may not trouble your honor by reading all these statements and the compilation of thousands of pages.
Relevant would be the statement of Varsha Bill itself,
Yes.
so far as POC is concerned.
So in this background of fact, I am humbly urging the honorable court to kindly allow this applicant lesson and discharge this accused person from this case.
Dhawan Mawani was kidnapped.
Yes, on the contrary, my son is the victim of the offence committed by the other accused persons who are facing another case.
Everyone is claiming to be victim in this offense. But the kidnapper says he is
એટલા માટે એ તો સાહેબ બધી દિવસોના દિવસો જશે એના માટે enter into that but dispute between the accused. That is why I have stated that accused number 1 is alleging something against accused number 2, my son. And then ultimately it is authority.
And the original owner, they are not traceable either by ED or either by the schedule of them. They have eloped out of India.
And I said, the main accused against whom I had filed the complaint of kidnapping, namely Silas Bird, he is behind the bars.
No, the owner of the Bitcoin company, who has floated this company,
Yet not traceable.
they are not traceable.
Not traceable.
સાહેબ આ બધા કેસોનો સાર એટલો જ છે બધા કેસો. Nowadays we are reading and going through this such type of cases. પેલા ગોપિયામાં ને
So far as the role of president accused is concerned, the approximately 9 crores of POC was transferred to by the accused number 1, the son of the present applicant, and he has purchased some properties in the name of his mother. I directly take my honor to the
Table B.
page number 8 of my reply, whereby I've specified the role of the present applicant, that properties to the tune of 2.66 crores were purchased in the name of the present applicant. The accused, number 1 himself, he in his statement dated 15th of February 2021, that is RUDO of our present complaint, he has admitted that he has provided the funds for the purchase of the money, for the purchase of the property, which were purchased in the name of the present applicant. It is the statement of accused number 1, sir, 15th of February 2021. Secondly, sir, then page number 8 of my reply, paragraph 2, sir. The paragraph here is Dhaval Mawani in accused number 2 in his statement dated 21st of January 2024 is stated as follows. Point A, that the property bearing document so and so was purchased in the name of his aunt Jyotiban Mawani, now deceased. The sale consideration was paid to the seller from the account bearing so and so held in the name of Jyotiban Rameshbhai Mawani with the State Bank of India, Mini Bazaar. Yes, I have mentioned that this is the details of the credit and debit entries has been provided in the table below, sir. From the above said transaction at page number 9, sir, just after the table, the above said credit transaction to the tune of 24 lakh were arranged by Suresh Gorasia, accused number 3 in the present PC, on the instruction of Satish Kumhani, that he did not know about the account of which the said transaction to the tune of 24 lakh were arranged by Suresh Gorasia in the account bearing number so and so held in the name of Jyotiban Mawani held with State Bank of India. Then the paragraph B. Dhaval Mawani further stated that the property bearing document number so and so and document number so and so mentioned at serial number 7 and 8, which is presently in the name of the present applicant, Varsha Ben, was purchased in the name of his mother, Srimati Varsha Ben Mawani, the applicant herein, and accused number 6 in the present case. The sale consideration was paid to the seller from the account bearing so and so held in the name of Varsha Ben with the Bank of Baroda. Along with this statement, Dhaval Mawani also submitted the self-attested copies of the statement of the said bearing account number held in the name of Varsha Ben, which is RD number 37 of the present, which contains the details of transactions pertaining to the purchase of the said property in the name of his mother. Then, sir, at page number 10, point number 3. Varsha Ben Mawani, the applicant here, in her statement as submitted dated 13th of August 2021, she which is RMD Y in the present complaint. She stated that she has purchased the property at serial number 7 and 8 of the table B above, from a person named Tripur Bhai Raghav Bhai for totaling rupees 36 lakh, that for the purchase of the said property, she has made the payment from her bank account, the source of which utilized by the said properties were as follows: a loan from one person named Rajesh, and secondly, a remaining amount of 12 lakh was received from her brother Hamaji Bhai Sutaria in various transactions. So she does not have her own source of fund. Such next paragraph is important with respect to the present. The applicant further stated that the said statement dated 13/8/21 that on request of her son, she has transferred rupees 25 lakh to Suresh Godasia on 15th of June 2017 from her bank account. So, firstly, she has made the payment from her own bank account, which was thereafter reversed and submitted back to the original source at the instance of his own son. And she does not have her own funds, and these properties were purchased out of the proceeds of crime, which was received by accused number 1, his son, and he has willfully assisted his son, to divert the properties by purchasing to divert the proceeds of crime by purchasing such and such properties, which has been detailed in the table.
Yes. Anything more?
One more paragraph I'll just.
Apart from any your reply, you want to say anything more?
I've stated in the
For
for the role of
two
the
contentions are raised by all the accused. One, they are not accused in FIR. Secondly, they are also not arrested, and they have cooperated, and they have no knowledge about the proceed of crime.
so far as not being named in the FIR, I'll refer to the Vijay Manlal Chaudhary, which specifically states that even if the person is not in the FIR, if at any point of time they have received the proceeds of crime and have not just they can be that property can be attached, but they can also be added as an accused. Para number 68 of the Vijay Manlal Chaudhary specifically stated. And para number 51 of the Vijay Manlal, it also specifically states that money laundering need not have to be even a person who has assisted in generation or concealment of any part of the money laundering, be it layering, then that person can would also be covered under the ambit of section 6.
So, next. For rest of the two,
Sir,
same argument, same reply.
Yes, sir. Their role is the same. They have assisted in the laundering of street. For 3, 4, 5, and 6, it's the same.
PC. Section 94 of DNSS can apply to get the documents produced. Documents produced. If a narrow view is taken by denying the opportunity to the accused, he will not be able in a position to discharge the burden on him, and therefore it will affect his right to liberty as he may be denied bail. The denial will amount to violation of his rights guaranteed under Article 21. Therefore, at the stage of hearing of bail application to which stringent provisions of Section 45(1) of the PML are applicable, the accused will be allowed to invoke the provisions of Section 91 of CRB seeking production of the documents not relied upon by the ED. But when the investigation is pending, while permitting the accused to seek production of documents that are not relied upon by invoking Section 91 of CRPC, care has to be taken to ensure that the investigation is not prejudiced. Therefore, when such an application is made, the ED is entitled to resist the production of documents that are not relied upon on the ground, and if the said documents are disclosed at the stage to the accused, it may prejudice the investigation. So, pausing here for the moment. So, the prosecution complaint was nowhere they state that the investigation they need to further investigate. Though the ED is not entitled to raise the said plea, it will have to show the documents to the court. The court can, for the reasons recorded, deny production of documents only if it is satisfied the disclosure of the documents are prejudiced the ongoing investigation. Needless to add that the ED cannot raise such an objection after the investigation is complete. Sir, investigation is complete as per the ED's prosecution complaint.
It won't be. It won't be. Investigation never gets completed. Then you will have to file your which document you are objecting to be handed over to them, and which document you are permitting him the copy be supplied.
It is permitted to submit this one. Of course, this Sarla Gupta judgment, as suggested, it is the furtherance of legislative intention, the ratio laid down in Kunnuswamy. So in Kunnuswamy, as far as
No,
the
no, no, no.
the disclosure is
No,
mandatory.
there is a, so far as Munnu or Punnu Swami is concerned, not only Punnu Swami, even in criminal reference or in reference trial guidelines, it was stated the stages are described there.
That was after framing of charge. In
After
Kunnuswamy,
framing of charge, then at the time of raising of this defense,
Right.
at the stage of evidence of defense, that application were to be considered. Now, but in view of this judgment, so far as ED is concerned, while earlier that non-relied or other documents supply that were not in the ED proceeding. Now, by virtue of this judgment, it is made clear, even in this case,
at the stage of bail also.
at the stage of bail also, and keeping in mind, section 45 rigors are there, and section 24 presumption is there. And therefore, the only objection which is kept open for you is that certain documents which are not relied by you at this stage, you can object by pointing out to the court that this would be the document which would seriously prejudice your investigation if it goes into the hands of the accused. And he may conceal that property or whatever proceed of crime. To that extent, you are right. But now that stage has gone.
Agreed, sir. What I meant to say, as far as the regarding of ratio of Kunnuswamy was, of course, after framing of charge. one
After
has to
framing of
disclose.
charge, he would be entitled for
Definitely.
documents.
Sir, I will be allowed to raise this line. As far as disclosure part is concerned, it was mandatory, and it is mandatory in Kunnuswamy. After disclosure of producing the list as per 17B paragraph of the judgment, as far as the requirement concerned of document, that would be the discretionary of this by this honorable court. મારે ડિસ્ક્લોઝ કરવું એ મેન્ડેટરી છે કે આટલા આટલા લિસ્ટ મેં આપી દીધું બનવા પાત્ર છે કે નહીં એ ડિસ્ક્રિપ્શન ઉપર જાય એ એમનો રાઈટ નથી ડિસ્ક્લોઝ કરાવવું એ રાઈટ છે તો ઇટ ઇઝ ઇન ટુ પાર્ટ્સ હવે જે બિલના સ્ટેજે છે મારું ઇન્વેસ્ટિગેશન નથી તો મેં લિસ્ટ આપી દીધું સાહેબ હવે as far as they have to satisfy the nature of document જુઓ સાહેબ they have to come forward કે આ ડોક્યુમેન્ટ આ પર્પસ માટે છે જેથી they can pray for discretion.
No, it won't be discretion. Discretion only when you object certain documents which should not go into the hands of the accused at this stage of hearing of bail application, coupled with the rider ke investigation, would be prejudiced. Otherwise, what was the earlier position in Munnuswamy and all the subsequent development? After framing of charges, he can invoke section 91 or he can invoke at a stage of his defense after prosecution evidence is completed. Till that, he was entitled only for list of documents, not list of any list of statements which you are not relying. But by virtue of this Sarla Verma,
They have to come with a specific request કે આમાં મોટા ભાગના ડોક્યુમેન્ટ ઇશ્યુઅન્સ ઓફ સમન્સ છે સમન્સના એમના રિપ્લાય છે એમના ઈમેલ છે જે બેઝ બનાવ્યો છે સેક્શન 24 ના બર્ડનનો તો એના અનુરૂપ કયા ડોક્યુમેન્ટ એમને જોઈએ છે બેલી એપ્લિકેશનના લિસ્ટમાં જોશો તો અમારામાં જે કમ્પાઇલેશનમાં જેમની બેલ એપ્લિકેશન એ પણ અમારામાં એક કમ્પાઇલેશનમાં તો અમે ડિસ્ક્લોઝ કર્યું કમ્પાઇલેશનમાં તમારી બેલ એપ્લિકેશન પછી રિપ્લાય પણ સમન્સ જે બધાને ઇશ્યુ કર્યા એ છે ને સમન્સ બાબતે જે ઈમેલ આવ્યા એક્યુઝ કે બીજા કોકના એ છે તો દે હેવ ટુ સેટિસ્ફાઈ કે સેક્શન 24 ના બર્ડન ડિસ્ચાર્જ કરવાની જે વાત છે આ સ્ટેજે પર એના રિલેટેડ રેલિવન્ટ ડોક્યુમેન્ટ કયા એમને આ લિસ્ટ ઓફ
yes, you will have to specify which document you want.
Sir, I would not be in the knowledge. Sir, today I have been provided with the list. Sir, in my respectful submission, the argument made by my learned senior friend is directly in contrary to what the judgment of the Supreme Court says. If my lords are kind enough to come back to paragraph 52, sir, the Honorable Supreme Court says in very clear terms that this denial will amount to a violation of his rights guaranteed under Article 21. Sir, it is my right to get those documents. I do not have to justify what documents I need. After the charge sheet is filed at the time of hearing of the bail application, it is my right to get those documents. So this is very specifically, very clearly stated by the Honorable Supreme Court.
What document under section 91 you want?
Sir, I have been provided with the list just at 3:05 p.m. Sir, I am going through the list. But sir, what appears prima facie from the list is this, that sir, the entire complaint is based on the SEBI complaint number 69. Now, there are certain communications which have been exchanged between ED and SEBI based on which I am made the accused. So for the purpose of satisfying the twin conditions of bail, I have to first point out that there is no prima facie case against me. Now, they have framed the case against me based on the SEBI complaint. There are certain communications which have been exchanged between ED and SEBI based on which I am made an accused. Sir, I need to see those documents. On what basis have they made me an accused? What was the information exchange between SEBI and ED? So that will help me dislodge the case under section 24.
Then see, he has provided you all the list.
Yes, sir.
Now list would be having some nomenclature.
Yes, sir.
You go through this. Okay, this would you would be required.
Sir, મને આપ્યું છે હું જોઈ લઉં sir. But sir,
He would be needing the summons issued to
Sir,
his client.
sir, I will,
What document-
sir, in my respectful submission.
Even see, even if I forget about this judgment and all this, section 91 would be, okay, you would require some documents, which as per your belief, it would help your case. Then you will have to mention that document while even in normal course, if you are making an application on section 91. Now today is giving you the list of document or list of statement of witnesses,
The list of documents.
list of documents.
Not part of the
Now
document.
that they are not relying upon them.
Please allow.
So once they are not relying on those documents, it should be believed that those documents would not be in the nature of such evidence for which you would be requiring to rebut the evidence, because at the first threshold, they are not relying upon those documents.
I bow down, sir. Sir, I bow down, sir. I bow down what is falling from the Honorable Court. So I need only those documents which I believe will help me dislodge the twin conditions.
He has said one.
But sir,
one or two
અત્યારે જ
things.
મને documents list આપ્યું છે. Sir, I'll take instructions. Sir, what I propose is this. Sir, I'll take instructions from my client. Sir, I'll provide a list of documents which I require from the alert statement. I take the inspection on those documents which I feel are necessary for my purposes, for the purpose of arguing bail.
Okay,
આ
you-
list છે, આ બધામાં તમારે
Okay, you do what-
તમારું burden છે.
Array, you do one. Whatever documents are already there on record, that is not required. Because those are relied documents by you. Now you have given him a list. Let him decide which document he wants.
Please, Your
And
Honor.
then he will mark out of 15 documents, he wants 5 documents.
આ આપ્યું સાહેબ લિસ્ટ આપ્યું હમણાં જ બોલો.
Then you verify.
Sir, હમણાં તો ના તમારે instruction
You
લેવી
also
પડે.
go through whether you are objecting to give those documents to the accused or not.
The application is under section 91, the old code, now it is 94. So that goes without words, any prayer under 91 would be discretionary. Of course, related to coming to the point of section 24, as far as the burden of accused, that is to be rebutted or discharged. So there has to be some relevancy, sir. એ જે document કે જે relevancy તો આપણે demonstrate કરવી પડશે ને.
Sir, I with utmost respect, sir, I am not able to follow. My learned friend is either objecting or not objecting. If he is objecting, he may say that he is objecting to certain, he may file a reply, I will deal with it.
The reply to I
But sir,
am answering it. I am answering your
On one hand, he is saying that he will be providing the documents. On the other hand, he is saying that he has right to object to it, and it is discretion. Sir, if I provide a list tomorrow,
Both are you claiming your right? Is
sir,
it
right versus right chahiye. There is no left. There is nothing left now.
તો હું આ
Both are you objecting and both are you?
એટલે 25મી આવી એપ્લિકેશન આપી દીધું, અત્યારે આનું નિરાકરણ આવી ગયું તો મેટર આગળ વધી ગયું. હું તો મેડમ
Sir, નિરાકરણ આવી જશે if my learned friend agrees to provide the documents.
આથી ઝડપ કેટલી હોય સાહેબ? 245 અરજી આપે 3 ને 5 એવું લિસ્ટ આપ્યું તો આથી ઝડપ કેટલી?
So I would say that the decision of Sarla Gupta was of 7th May.
પણ બધા કેસોમાં સૂચના આપી દીધી સાહેબ, બધા કેસોમાં pending
No,
કેસોમાં
7th May, if he
બધામાં
rea-
સૂચના કેમ?
If he really intended, then he would have filed at least by 30th of May. Instead of asking for time. This application would have been decided by that time.
એ તો બ્લેન્કેટ સૂચના આપી દીધી કે ઘણી ડિસ્ચાર્જ એપ્લિકેશન અટકી પડી છે, અમારા તરફથી રેડી રહેશે, પણ એક તો છે કે કોપી
Ah,
એટલે બધાને